All day, I also will add you to the case if you want to continue this. This needs to be dismissed today.
Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing gum, or reading any material. Thank you.
Thank you. This is case number 23-152244. This is Javar Grayson versus Brian Ambrose. The matter is before the court where there is an application for entry of a default judgment. The court has set the matter on in regard to that motion. Your appearance for any attorney who's appearing on either side, your appearance in first instance, please.
Thank you, Your Honor. Christopher Michaels, P83156, on behalf of Police Officer Brian Ambrose. And briefly, there was also the defendant's motion to dismiss in lieu of answer was filed. I don't know if today is the date and time for that as well.
I do have that matter that was filed with the court June the 30th and submitted to the court. So that is an issue that's before the court as well. All right, and do I have Javar Grayson on the Zoom? Say something if you're here at this time.
Yes, Your Honor. Javar Grayson.
Before we jump back into Judge Coleman's courtroom, you need to understand something important. This isn't a misunderstanding, and it's definitely not a one-off mistake. This is a repeat performance. The same arguments, the same confidence, and the same refusal to accept reality. We're dealing with a sovereign citizen who genuinely believes legal words are magic spells and that declaring yourself exempt somehow overrides centuries of law. Today's hearing picks up exactly where the last one left off, and what you're about to watch is the slow-motion collision between internet fantasy and courtroom procedure. The judge knows this playbook. The attorney knows it too. The only person who doesn't seem to know how this ends is the person standing at the microphone. And once the logic starts unraveling, there's no stopping it.
Good morning.
All right, I see that there is let me address the issue of the application for entry of default judgment in this matter. On what basis are you saying, Mr. Grayson, that you should be entitled to entry of default judgment in this matter, sir?
Well, Your Honor, we sent documents into you stating that I'm a national, a Morris American, and this highwayman has no jurisdiction over me, and we sent that information to you, and also sent, I believe I have a court, People versus Battle as a reference in the case.
I think that you're addressing something that don't have anything to do with my question. You submitted to the court a default request. Now, on one hand, you're telling me that the court doesn't have jurisdiction. You're telling me that the court doesn't have jurisdiction, and you're not sitting into the jurisdiction of the court. Then why are you filing something?
Context with this court tried to enforce jurisdiction on you.
I'm sorry, the jurisdiction that doesn't have jurisdiction, the 36th District Court, a traffic court, that's not pertaining to you. What I decided to do was send you basically every information to communicate what I've been doing basically in 36th District Court, as well as this procedure.
I'm not a traffic court judge. I'm a civil judge. But I don't know what are you talking about?
Yes, sir. And I understand that.
All right, Mr. Michaels, address yourself, if you will, to both issues. One is the motion for entry of default, and then secondly, which I believe these issues might collide, the motion to dismiss in lieu of filing an answer, sir. Go right ahead, sir.
Thank you, Your Honor. I did receive a copy of the request for default this week, so I had no opportunity to respond. Obviously, the city or the city law department who's representing this police officer filed its motion back in June, dismiss in lieu of an answer. So I don't believe there's any grounds whatsoever for a default judgment. The brief speaks pretty clearly on its face for why a dismissal is appropriate. There is no viable claim stated in plaintiff's original complaint and since the defendant is was at the time and still is a police officer, he would be entitled to governmental immunity. It appears that it's some sort of dispute regarding traffic tickets or citations that were given for various matters that are currently pending in front of Judge Perkins right now. So it also appears to be some sort of collateral attack.
And here it is, the classic sovereign citizen confidence boost. Representing myself. That statement always comes with a tone of absolute certainty, like they've cracked some hidden legal code no one else understands. But confidence without comprehension is dangerous, especially in a courtroom. Judges don't rule on vibes, beliefs, or YouTube research. They rule on law and procedure. The problem is, people like this mistake assertiveness for authority. They believe speaking louder or longer makes the argument stronger. It doesn't. All it does is give the court more material to dismantle. And as we're about to see, Judge Coleman isn't impressed by bravado. He's listening for legal relevance. And that's where this case immediately starts falling apart.
Certainly, let me begin with the default request. I don't see where the defendant is in default in this matter. He's responded to the complaint. Default is when a party fails to act in the judicial proceeding, in a court proceeding, failed to act when they should have acted, and that therefore the court would be required to enter their default because of their failure. Things like failure to answer the complaint or failure to file a responsive pleading. The responsive pleading that was filed in this matter was filed in June. The case was filed, looks like June the 13th of 2023. The motion was filed June the 30th. So that's certainly within the time required by law to do a responsive pleading. So I don't see any basis for default. Default is what, like if the defendant did not answer or didn't file a response, then the plaintiff could move for entry of default. I don't see a basis for entry of default in this matter. No, so the motion and application for entry of default is denied. There's nothing about this case that shows that the plaintiff is in default, or for that matter, that defendant is in default on anything. Neither party is in default. The case is right where it's supposed to be, and that is that there's been a complaint filed, and then there's been a responsive pleading. That responsive pleading is a motion to dismiss in lieu of filing an answer. If the plaintiff didn't file, straight that if the defendant didn't file a motion, he would have had to file an answer to the complaint. So when there's a complaint, you got to answer within a certain period of time by either filing a written answer or by filing a motion. Sometimes there's a motion for a more definite statement. Sometimes there's a motion to dismiss because the complaint is deficient or it has some legal flaw involved. This motion to dismiss in lieu of answer is filed alleging and arguing that summary disposition should be granted, or that a motion that the court should dismiss the case because there's no legal grounds, factual grounds for this case to stand on. What is this case about, Mr. Grayson, sir?
It's about a traffic, I guess is some type of traffic ticket. It started off Brian Ambrosius stopping me, and I believe I have the right to travel.
This exchange is the first major crack in the argument. The defendant wants a default judgment, while simultaneously insisting the court has no jurisdiction over him. That's not a legal strategy. That's a contradiction. Default judgment only exists inside the authority of a court. You can't deny jurisdiction and then demand enforcement from the same institution you claim has no power. Judge Coleman catches this instantly, and you can hear the confusion, not because the law is unclear, but because the logic makes no sense. This is sovereign citizen reasoning in a nutshell. Reject authority, then demand its benefits. Courts don't work that way, and the judge is already steering this toward a reality check.
And I do understand the default judgment, that you are saying, and what it's pertaining to. We are still ready to proceed with the case.
What exactly is your cause of action? Because I don't think that you stated a cause of action that upon which the court could move forward with the complaint.
Well, actually, in traffic court 936 district, there's actions being taken against me as we speak. This is a current case, and 36 district court has no jurisdiction over me. That's why I decided to bring it into civil court common law. And this is a 6-month case that's still going on. So,
all right, Mr. Michael, you get the last word on your motion.
Right. Yes. Very briefly, there was nothing filed by plaintiff. And it does sound like he's disputing his traffic tickets in this court, which is a collateral attack, which the Michigan court rules and do not allow. So I think that's the best ground to dismiss this case, and we would ask this court.
I object, Your Honor. I'm disputing my birthright. I'm disputing.
I got it. All right. That you failed to state of action upon which the court can grant relief. This case and the complaint in this matter will be dismissed. It's dismissed without prejudice, meaning that if you could formulate a cause of action that is recognized in the Michigan law, then you can bring the matter. If you can formulate case law or some type of law that supports your cause of action. It sounds like part of what is being said here is that as a sovereign person, you have the right to travel and et cetera, et cetera. And there is some basis for the same, but yet there is law that allows for law enforcement to stop individuals that are traveling upon the roadways. And so if that is what the cause of action is that they don't have the right to stop me, there is nothing in Michigan law that recognizes that. If, on the other hand, you find some basis to establish that that the stop was in the form of some illegal activity, harassment, some advance against your person that is not permitted under law, or done under color of law but not permitted under the Constitution, then you certainly have the right to bring an action here or in circuit court or in federal court. This case does not have any grounding to it. For that reason, the complaint is dismissed in this matter. Again, and the complaint is dismissed without prejudice. That would be a final order regarding this particular file. Good day to both sides.
This is where the wheels really come off. The defendant keeps bouncing between courts, jurisdictions, and labels like traffic court without understanding what any of them actually mean. Judge Coleman has to stop the conversation just to clarify something basic. This isn't traffic court, and that distinction matters. You can't randomly relocate a case to civil court because you don't like what's happening elsewhere. Courts don't exist as menu options. They exist by statute and jurisdiction. This moment exposes the core issue. The defendant isn't confused about one rule. He's confused about how the entire system functions. And that misunderstanding is about to cost him the case.
The case of the People versus Stephen Johnston.
Okay, Richard McDuffie for the people. And Alexander on behalf of the people, Your Honor.
Assistant Public Defender Nicholas Bukovich on behalf of Mr. Johnston.
All right. I put this over to this afternoon. What have we determined?
Yes.
Good evening, Your Honor. Well, good afternoon, brother.
Yes.
All right.
First, I know Mr. Johnson was able to speak to one of my colleagues when I was in court this morning. We will be, I know we have a green sheet in there. He will be waiving his PE for this to go over to circuit court. I will have him fill out that form momentarily, Your Honor.
So he's waiving up?
Yes, he'll be waiving up.
All right. Is there any issue I need to do with bond on this then?
Your Honor, at this time, we would be asking for a no contact order to be put in place.
I thought you did give the change this morning.
Kristen Kinduski, Your Honor.
Okay, help me. Name.
Can we
Yes. I need counsel. Go ahead. Go ahead.
Yes. So in addressing the prosecution's request for no contact, Abby is saying per his probation cases, he does have a consensual contact order with the complaining witness in those cases. She did make a 40-minute victim's impact statement confirming that she did want contact. I can confirm this with his APD who represented him at the circuit court level. Judge Conkey there made a determination that contact would be proper if it was consensual contact. Similarly, this was a request that was made at arraignment on this case. I was not myself who handled it, my colleague. However, Magistrate Otella there also made a determination based upon the allegations related to this case, which is two R&Os and alleged two R&Os and a possession that no contact order was needed. The alleged complaining witnesses in this case before you at this moment would be the police officers, not the complaining witness from his past.
Defense attorney just did is quietly devastating. No theatrics, no insults, just clean legal reasoning. He explains that the request for default fails procedurally, that the complaint fails substantively, and that the officer is protected by governmental immunity. Translation: even if everything else were ignored, this case still goes nowhere. Courts don't entertain retaliatory filings or collateral attacks on traffic cases disguised as civil rights claims. This isn't complicated law, it's foundational, and the judge already knows it. This moment seals the direction of the ruling long before it's officially announced.
Meaning phone calls that were made, which one could look at as interfering or otherwise attempting to try to obstruct this proceeding.
While context may be changed, he has indicated that prior to this, he was never near her. I understand the concerns that you're addressing with these phone calls. However, again, they are still not a violation of his previous probation. So
right, okay, so that we're not getting. So that we're clear in what I'm saying. I'm not saying that they're necessarily a violation because the no contact does not exist. I guess I'll put it that way. I mean, it's permitted contact. But once that contact then begins to happen, the subject matter of that particular contact, what's said, could change those circumstances, I guess, in terms of whether or not contact should continue to be permitted. I mean, if somebody calls and is making either threats or some other type of statement to someone, that could lead the court to then.
Here we hit one of the most recycled myths on the internet, the so-called right to travel. This argument shows up in sovereign citizen cases constantly, and it never works. Yes, people have a right to travel, but that doesn't mean freedom from traffic laws, licensing requirements, or lawful stops. Judge Coleman is patient here, but firm. He acknowledges the concept while explaining its limits, which is exactly how courts handle these claims. The defendant, however, treats right to travel like a trump card. It isn't, and the law has been crystal clear on that for decades.
I was addressing.
Just one more time to reiterate for the purpose of bond. Those calls can also not be interpreted in a way that is non-threatening, so I would still be asking for a...
You're saying they could be interpreted as a way of non-threatening?
Yes. So I would still be reiterating that I would be asking for no modification in bond and no contact order to be put in place.
Is there anything from the people on that?
There is, Your Honor. So first of all, I want to point out that at the arraignment with Magistrate Otella, Mr. Bukovich and I were both present. As he mentioned, it was his colleague that handled the arraignment. There was not an extended back and forth about the no contact provision. We made the request, it was articulated on a recommendation form, and the magistrate declined to order it. But there was no, honestly, it could be that it just slipped his mind in terms of that being a request, and I maybe should have done a better job of reminding him about it. But I want to point out there was not an explicit denial of that request on a basis of it not being necessary. Second, I understand that this was prior to sentencing. In the GBH case that Mr. Johnson had with this same victim, I understand she's not a victim in this case, he previously had an issue where his wrong privileges were revoked first. Then there was a motion for forfeiture by wrongdoing. It ended up not being necessary because the case was found over at exam. He continued to contact her after that, discussing the fact that she did not want to cooperate